We're now joined via Teams by legal analyst Elton Hart. Mr. Hart, thank you so much for your time this afternoon. So the Pietermaritzburg High Court and, of course, the Supreme Court of Appeal both found against the former President Jacob Zuma, but he's now approaching the Constitutional Court because largely he still believes a private prosecution does exist. What is the likelihood that this latest bid will be successful for the former president?
Now, normally if you look at appeals courts don't like to interfere with judgments of courts of lower standing than them. And in this case, I don't think that the Constitutional Court will easily interfere with the High Court's judgment because they had sight of the papers, they had oral evidence, if there was any oral evidence that had to be led. So it will be very difficult for Mr. Zuma to go to the appeals court and say, listen, yeah, this is not an abuse of process. And I actually see that I have merit in my case and you will come to a different conclusion. I'm not saying it's impossible, but it's very tough for him to actually get that ruling by the SCA as well as the High Court overturned because case law is against him. Yes, you can challenge case law, but as it stands, it will be very difficult for him to get over that hurdle to show that there is actually merit to his private prosecution and it's not just a mere delay tactic as most of the arguments from Billy Downer and Karyn Maughan's side was that it was just plain delaying tactics to avoid the arms deal to start.
So how best then can he convince the court, that there were no exceptional circumstances which warranted the High Court to pause his private prosecution while he actually prosecutes his appeals, to finality, as one analyst suggested earlier on?
No, indeed, if you look at it, he needs to convince the High Court. But obviously, as I said, case law is against him because you have the City of Tshwane case. And there was also now an enforceability ruling because he wanted them to sit in the dock and actually attend to this matter while in the dock because it's still a criminal trial. We see that the trial has been postponed till the 9th of April 2024. But for him to actually go and convince the court, it means that he has to now get case law. And sometimes our constitution allows to even go and look at international case law to say, listen, yeah, he's got a case to answer. These two guys, whoever sort of have dispatched his or made public his confidential information without his consent is violating a statute, which is the privacy laws that we have in our country, and he needs to base his heads of argument around that. Obviously, with the application already being heard in the High Court and now in the Supreme Court of Appeal, you are sort of half in chains, in shackles, he is, because he needs to stick to the papers, what's on record. He cannot adduce additional and new things. He just needs to now carve his heads of argument and using case law that is advantageous to him to say that, listen here, private prosecution is on the table. These guys actually violated the privacy laws and in that so violated Mr. Zuma's constitutional rights. That's the only thing that I can think of how he can actually pursue and proceed with this matter to try and see if he can get success in the Constitutional Court.
And I mean, you've said, case law is against him several times now. One wonders then, what is the strategy of his legal counsel? I mean, he has been accused continuously, we know, of applying Stalingrad tactics. Is this what we're seeing now?
Yes, if we look at case law, I'm specifically referring to South African case law, but there's nothing stopping you and actually introducing in the Constitutional Court specifically international case law, because Section 39 of the Constitution says you can use international case law to develop our case law. So he can utilize international case law to say, yes, our courts have been applying this principle, but in line with international standards and norms, this is incorrect. This is how the court should look at these types of applications, and not as how we used to look at it, because we did not look at the international arena that South Africa forms part of. And I think that is where, of course, Advocate Nkaitobi, he actually referred to the Superior Courts Act and made specific mention to certain things, and that's legislated. So it sort of half curbs and narrows down what tools Mr. Zuma can use, our former president can use in this regard. So it's important then he has to look at international case law when he drafts his heads of argument for the Constitutional Court, that he also brings those international views, and especially from what we call the Anglo-Saxon countries that there's similar sort of half legal frameworks as ours, to actually help him in actually sort of half creating new law and put us on a new trajectory in terms of private prosecutions.
So where does then the road lead or end, dare I say, for the former president, should this bid fail?
Now, if the Constitutional Court, because obviously now he's asking for leave to appeal to the Constitutional Court, if they say that there is no grounds for leave to appeal, then that's the end of the road for him. Then he must now face the trial, and then the private prosecution is off the table. If they allow him to enter the court, if one can use it loosely, then it will mean that in next year, most probably, they will hear this matter and see if his private prosecution is actually an abuse of court process, or does it actually have does he have a right in law to actually prosecute Billy Down and Karyn Maughan in terms of the certificate of nolli prosecute? So that's where it is. So if the Constitutional Court say no merits, end of the road, then it means that we will soon see the arms deal trial being placed on the roll or be enrolled again, and then he will have to stand trial and answer to those charges leveled against him.
And to what extent would this process, be impactful for for his main trial? In fact, the arms deal case. Then,
no, obviously, if he gets it right, and they say that he can actually privately prosecute Billy Down and Karyn Maughan for leaking his confidential information, then it will mean that Billy Downer will no longer be the lead prosecutor in the arms deal case, because clearly it shows that he has sort of have a conflict of interest, because if he prosecutes him on the one side and he prosecutes, Billy Downer prosecutes the former president on the other side, it means that there's a conflict of interest. So then we'll need to see a new prosecutor being brought on by the NPA to actually take over the matter. And obviously it cannot also be Breitenbach, because I believe Breitenbach was also somehow implicated in the leaking of the documents. So the NPA should already maybe gear itself to say, in case the Constitutional Court says, former president, you are right, Billy Down and Karyn Maughan, you were wrong, then for somebody else to prosecute the arms deal case. So otherwise that case will also fall by the wayside and not being prosecuted. And we know Billy Downer was working on that case for a very, very long time. So he has got good insight into the case, but he can also prepare good memos for a person to take over. And there's nothing stopping him from on the side saying, okay, this is the strategy that I had with the case, and shared with his colleagues to actually prosecute the case. But we know that he wants Billy Downer as far removed from the arms deal case as possible. Hence, he's also now proceeding with his private prosecution.